Hey everybody, it's Paul Yokobitis from Cary Estate Planning, back with another video as part of our 2020 video challenge. And today I wanted to talk about the small estate filing called the Petition for Years Allowance. And this is something that is usually going to be unique to the surviving spouse of a deceased individual or their minor kids. And so the most common filing that we make in a small estate manner or for the resolution of an estate is probably the spousal allowance. And essentially what it allows is for the surviving spouse to petition to the court through a 2-page pleading. It usually costs about $8 to file, plus the cost of filing the will if needed, to essentially move title from a deceased spouse's name to their surviving spouse's name. And it's often utilized to transfer car titles or individual bank accounts that have the deceased's name on it. It essentially entitles the surviving spouse to the first $60,000 of personal property from the deceased spouse's estate. And that amount is essentially, it's not guaranteeing $60,000, but it's up to $60,000. So sometimes there will only be, 10 or 20,000. And if that is the case, then the surviving spouse will get what's called a judgment, a deficiency judgment against the estate, to essentially say that if there are any other assets that may be found later, instead of those assets potentially going to creditors, the spouse becomes the primary creditor against the estate and is entitled to, basically withdraw or transfer those assets against the deficiency judgment at that time. So it ends up being sort of protective for the surviving spouse. But probably the most popular and most important small estate filing in North Carolina. This is Paul from Cary Estate Planning.